This is our final screenshot video for the civil practice course. We're in weeks 13 to 14. We're looking at discovery. The posting I put up, or the notes I put up, was on e-discovery, discovery of digital information. I have a extra credit project about e-discovery, so if you're interested in e-discovery beyond what I have in that posting, that would be a great opportunity for you to learn more about e-discovery and also pick up some points. So what I'm doing here in this screenshot video is going to the course textual handout, and I'm beginning at page 31, and I'm going to walk through some concepts and types of discovery. In the Buffalo Creek disaster, by the way, I hope that one takeaway you have about discovery is how critically important it is to develop a lawsuit. And the beginning, I don't know, I would say around 1950, and of course you weren't around then, but beginning in around 1950, what happened is in civil lawsuits, discovery just started to expand. The opportunities for discovery expanded. The idea was that a trial should not be a trial by ambush, where one is taken by surprise, and parties to a civil lawsuit should be able to discover almost anything they want to relative to information connected to the lawsuit, either from the other party or from people who are not parties to the lawsuit. And having talked about e-discovery, let me tell you, just because I love the story, and I did nothing of any significance except play a part in the story, which maybe is the best thing. So years and years ago, I was working with another lawyer. We were defending an estate in a will contest. In other words, the idea was, or the claim was, that the person who died, the testator, the person who made the will, wasn't of sound mind when he made the will. And I'm not going to get into the rules regarding will contest, but there was a lawsuit. And what we did, and it was just pro forma, meaning we had it already available. It wasn't in digital format, but we pulled it out, tweaked it, and sent it to the lawyer representing the claimants. And the claimants were the two children of the deceased. And what had happened was the deceased had been married, and the mother of the children spirited the children away. This was back before World War II, and he could never find the kids. A couple of times, these folks were both from Italy. A couple of times he went to Italy because he thought the kids were living there, could never find them. Now he comes back to the United States, and he meets a woman who had a little boy. At the time, the little boy's father was killed in World War II, and he marries the woman, and he never adopts the little boy, but he raises him as his own child, brings him into his very successful business, which was kind of a body shop, repair, collision shop, whatever business, but very, very successful. And he teaches, by now, this young man the ins and outs of the business. And then one day there's a phone call, and the old guy, who's still alive, answers the phone, and in his gruff voice says, "Who's this?" And a woman says, "Daddy, is that you?" Now, how did I know about this conversation? Well, in response to our discovery demand, which included a demand for any and all video and audio recordings between the claimants and the deceased, I got a box full of cassette tapes. And so I'm sitting in my law office, which back then was in the attic. It was really cool. I loved it. In the attic of a house up on Elmwood Avenue, and it's around 10 o'clock at night, and I've got a boom box, high tech, right? And I'm listening to these cassettes on the boom box, and I'm listening to these conversations between the claimant, the daughter, who was by now an adult woman, and the deceased. And what she had done was, without his knowledge, but it was legal, but without his knowledge, she had recorded all of these phone calls. And of course, you can imagine how overcome with emotion he was, at least during the beginning phone calls, etc. So just imagine if we had not made that request for discovery, and all it was a pro forma request. So this isn't anything where it's like, wow, that was pretty smart of you. That was just what you do. But if we hadn't made that request, we would have gone to trial, and we would have been entirely unprepared for these for these audio recordings. Because we were prepared, we had legal objections to their admissibility. We had a strategy worked out if they were admissible. We had, thus cross-examination questions to ask this person, like, so did you ever tell your father, like, that you were making these recordings? Well, why did you make the recordings? Why did you continue to make the recordings? Were you setting this lawsuit up from the very beginning? Not that that would be the specific question you could ask, but notice how all of this stuff, all of these opportunities open up for us simply because we made the demand. So I just always like that as a good story about how useful discovery is and how easy it is to get it. Okay, so what can we not discover? And there's 3 essential limitations on the right to discovery. First of all, the information has to be relevant to the lawsuit. Well, most information is relevant to the lawsuit, or why does somebody want it? I've run into some areas, however, where in a recent case that I don't want to talk about, where a lawyer is, I think, engaging in overly aggressive bullying kind of tactics and wants to harass people and is seeking irrelevant information. And so what do we do? If we think that a discovery request or demand is inappropriate, we can go to court. We can make a motion. In this case, our motion will be for a protective order. Most of the time, what people want is relevant. That's why they want it. But there's a second limitation on discovery, and that is privileged information. And one of my concerns about the case I was just talking about is not only is the information not relevant, but the person involved was an employee of another lawyer, and I think it's going to raise concerns about evidentiary privileges, and because the case is kind of dicey, even Fifth Amendment privileges. But if it's privileged information, and I'll defer to your evidence course, it cannot be disclosed. And then the third area is attorney work product cannot be discovered. Most of the time there's some exceptions. So I noticed that memos to file that the attorney is prepared regarding the case would be an example of attorney work product. I know it's my practice whenever I talk with someone about a case, I try not to take notes if I think that their statements might be an object of discovery. Instead, after I finish talking with them, I'll make a memo to file where I generally summarize what I've learned without doing it in the form of a statement, and most of the time I can protect that from disclosure under attorney work product. Okay, and I noted that if discovery request is improper, we can make a motion for a protective order. And by the way, if we make a discovery request that is proper and the other party refuses to give it to us, we can make a motion, and we would cross motion if there was already a motion out there for protective order. We would make a motion to compel discovery. Now, what are the discovery techniques? And again, I would defer to the e-discovery that I've talked about, but these are the more traditional pre-electronic discovery techniques. In a personal injury case, what's going to happen if we're representing the plaintiff, hurt in a car plaintiff, the defense will always send us a demand for a bill of particulars. And that's called really an amplification of pleading, so it's not technically discovery. By the way, it's not permitted in federal courts, but it's like discovery. And what we've got to do is particularize the allegations in the pleading by answering the demands, which will ask for all kinds of specific things, including medical treatment and so on. It's I can understand why it's appropriate. It's a pain in the neck to respond to, but that's the bill of particulars. Second one is written interrogatories. We don't see that technique used in personal injury cases because you can't use it along with the demand for a bill of particulars. I've seen it used, like, say, in commercial breach of contract cases, but it's a series of written questions. One party serves upon the other. That have to be answered in writing under oath. Now, what's going to happen is the lawyer is going to craft the answers for the other party. The other party obviously has to say, yes, that's accurate. But, there's 100 different ways to say something, and the lawyer will try to answer the questions in writing that the client will sign off on in a way to disclose as little as possible, because that's what lawyers do. And so we end up with probably the richest or most fruitful discovery technique, deposition on oral questions. And in New York State, this is often referred to as an EBT, an examination before trial. And we can get a party or a non-party to attend a deposition. If it's a non-party, we serve that person with a subpoena. Now we got the lawyers for the parties. We've got the person being questioned. We don't have a judge. If there's a problem that arises, we either agree to defer it and get a judicial ruling. Sometimes we even will just call the judge during the deposition, get the judge's clerk, see if we can get the judge to weigh in on what we present to the judge as our dispute. Then you end up with a deposition transcript. Oftentimes, again, I'll defer to the evidence course, can be introduced as evidence in chief as part of a party's case. It can always be used to impeach the credibility of a party. Plus, we learn an awful lot, and it's really, again, I think the most useful form of discovery. Then again, as useful, I guess, in some cases, is document production. And this is where we end up with the e-discovery, is this document production stuff. And so we could say, really, e-discovery is a more specific form of documentary production. And then we have our physical inspection. Sometimes there's an item that we want to physically inspect that we don't have control over. And then I mentioned the remedies for failure to disclose. Let me just, before I finish this video, make a piece of free advice, which typically is what you pay for it. But if you're involved in a lawsuit as a paralegal or a lawyer, and I don't care if it's civil or criminal, you're working on it. If there's a physical location connected to the lawsuit, go to it. I'm not talking about forensic examinations and experts. We'll get all of those folks in, but just go there so you develop a feel for the place, so that when people talk about it, you have in your mind, yeah, it's here, it's there. I can't tell you how helpful that has been to me in civil cases and criminal cases, just by driving over and walking around the corner of this place or the intersection of that road. Okay, this will end this video.